In Chapter 13, debt consolidation plans, we generally include the majority or all of the fees and costs in the payment plan. We go in right along with all the other creditors and expenses. In most instances in a Chapter 7, we handle our fees and costs up front. I'm going to turn it to Ron now so he has plenty of time. Thank you.
Do y'all have another half hour? Hopefully. My name is Ron Sykstus. I was born and raised in Chicago, and so you'll hear a little bit of an accent, though I think the last 10 years with Amy has kind of mollified my accent a little bit, and I've picked up a little bit of, I guess, Southern language. But in any event, what I'm going to talk to you about today, I'm going to switch gears a little bit, and I want to talk about security clearances. And if we have some time permitting, and hopefully we will, I want to touch on a couple of important consumer laws which I've provided in your materials. Can I see a show of hands of who's had a security clearance, either does now or has had one? Okay, so a good amount, and you know, obviously where we live, I always tell folks, I mean, a clearance is paramount to the types of good jobs that we have here. A security clearance is a government designation that allows individuals to have access to classified materials. And what I tell folks is, you know, maybe 6, 7 years ago, I would say 30%, and if anyone disagrees with me, let me know. Maybe 30% of the work that the government and the contractors did was classified. Now I would say within the last 2 to 3 years, I would say it's about 60%. Does that seem about right? Well, let's say it's going more and more to classified material. So when someone gets a job, either a government job or a defense job, a defense contractor job that requires a clearance, they tell them, you know, they put in for a security clearance for that individual. I never get involved unless the clearance is denied or revoked. So a couple of ways it happens, and I just kind of want to talk about evolution of a case from my perspective. So first of all, someone has a clearance and they get what's called a statement of reasons to revoke the clearance by the government. Believe me, that sends off warning bells for everyone, and y'all may have known some folks who've gotten that. Or if someone applies for a clearance at the outset and the government says, I'm going to issue you a statement of reasons, or the government's going to issue a statement of reasons that we're not going to give you a clearance. So term of art is the statement of reasons, and that's issued by the government when they're going to either deny or revoke clearance. And it'll give specific reasons why the government doesn't want to give a clearance. And I've put a little something in your materials. It's DoD Directive 5220.6, and that controls everything with regard to a clearance. I didn't give you the whole regulation. I didn't figure you'd need it, but at least you've got the reference materials. So when you're given this statement of intent or statement of reasons to revoke a clearance, it'll say you can submit a rebuttal statement or you can request a hearing before an administrative law judge. So the applicant generally has two options once they get this statement of reasons. And again, in this town, you know, and it's obviously this way in DC, when someone gets this, I mean, they are catatonic. And again, two options. They can submit this response in writing. And for those of you who know about the government, I would never do that. And I'll talk about that in a little bit. Because all it does is travel up to Fort Meade, Maryland, and this is my analogy. A clerk at Fort Meade sees it right before lunch and says, no clearance, and you're done. So all it is a written statement you can submit with some supporting documents why you should be given a clearance. Now the other option is to request a hearing before an administrative law judge. And now that kind of turns it into an adversarial proceeding. So these hearings before a judge, they're adversarial. Both parties present their case. That's the duty. I mean, the applicant has a duty to present his or her case. So does the government. The government will have a defense counsel representing their case. Now the applicant has the option of representing himself or being represented by an attorney, and this is not one of those bailout issues, by an attorney that he or she selects and pays for, unfortunately, and or also a personal representative. They can have a friend do it, a parent, a security officer. The government won't touch that, but a lot of times I've seen security officers at facilities do it for them. And some of them, I can think of two, do a wonderful job. Now, I think presenting a case, they can of course do it alone. I really try to discourage that. At a minimum, I'd rather see them do it with a third party. Because it just sounds hollow when someone does a case on their own. You know, Your Honor, I'm a great guy, and let me tell you about all the wonderful things I've done. That kind of rings hollow versus a third party, a third party presenting the case. Now the hearings, I told you it's based out of Fort Meade, Maryland, but the hearings are held in our locality, the locality of the applicant. So that's not bad, and as a general rule, the hearings here will be held in Huntsville. And in fact, I've had, I think, 3 or 4 hearings in this building. So it's a pretty informal process, which I'll get to in a second. As far as the process itself, as I said, it's an adversarial process, but the judge is not empowered to issue a subpoena for witnesses or documents. So anything that you want to bring as the applicant, you've got to provide yourself. You've got to provide your own witnesses and your own documents. When I say documents, I'm talking, evidentiary documents, which I'll get into in a second. If you have a lawyer representing you, that lawyer has to issue what's called a notice of appearance with both the department lawyer, the department counsel, and the hearing office itself at Fort Meade. With regard to these cases, wide degree of discretion as far as presenting your cases. Here's kind of the trick. Rules of evidence, you think they would, but they don't apply. And what that means is everything comes in. I've seen government documents, this always kills me. I've had cases that are like foreign influence cases where the government says, hey, we don't want to give you a clearance or we want to deny your clearance because you've had some issues with a foreign country, Thailand, Taiwan. But the government will introduce 5-year-old documents, to say, off of Google, that's where they get them, that say, hey, we've got, our country has issues with this country. As a result, we've got concerns for you. But they'll ignore a 6-month-old document that says we sold $2 billion worth of weapons to this country. So, but again, and when I get these documents, a quick Google search will usually give me more updated facts. So the way I look at a case, I always request a hearing. I've already kind of said that, but I think that's the way you start it. I really think submitting a rebuttal statement is a waste of time, and it's as good as waving goodbye to the clearance. And again, for the jobs in this area, that have a clearance, it's important, and longer term, it's important for advancement, and because in my assessment, once folks get a clearance, they can move up the chain pretty quickly. So. As far as presenting a case, there's 1 of 2 ways you present a case. So the government says, here, we're going to issue this statement of reasons of why we're going to revoke your clearance, and here's all the conduct that you've done. This is why we want to pull it from you. So you can do it 1 of 2 ways. You present it where you contest the conduct. Hey, this conduct never happened, or, which I will say I've never seen, the conduct's always happened. And we kind of know that because I said the rules of evidence don't apply. So they've got all these documents already in evidence as far as unsworn statements, police reports, it all comes in. Divorce decrees, bad checks. All this stuff's in. Some of it's illegible, but it's there. So I've never had a case where I could fight and say, hey, this didn't happen. So I always present it or approach it from the standpoint it did happen. So what I want to do is explain the conduct in great detail. That's how I approach a case. In my cases, the applicant always testifies. Now, I don't want to give away too many of my trade secrets, but applicant always testifies, and I like to kind of walk through the conduct. Sometimes in excruciating detail. But the reason I do that is I want to take the sting out of any cross-examination questions. Supporting witnesses. You can bring in 2 types of witnesses. Conduct witnesses and character witnesses. I want to have both. I want to have witnesses come in that talk about, the character of this guy or this girl. Hey, she's wonderful, and this is what she does in the community. I've had pastors testify, which I think is great. A lot of these judges are from Virginia. In my experience, when I was in the JAG Corps, I was stationed in Virginia for a period of time. It's much like Alabama, it's a very church-going population. So if I can get a pastor in, that really helps our cause, if they attend church regularly. So I also want conduct witnesses, and if we have someone, sometimes the conduct can be a little, for lack of a better phrase, a little unseemly. But if we can get into that a little bit with conduct witnesses who know about it and who can kind of explain it away, that's very helpful to our cause. I said the judges don't have subpoena power to produce documentary evidence, but what I like to do is get all sorts of, awards. Can I see a show of hands prior military? OERs, I like to get officer efficiency reports, and in my day, and maybe in y'all's, in my day, they were greatly inflated, though I don't like to tell that. They usually look great. EERs, enlisted efficiency reports, I'll get those if we have prior military experience. A lot of the contractors here in town and the government issue yearly performance appraisals, which are another great source of evidence. And again, generally, as long as you've been a good employee, they're going to look good. So I introduce that. I've done college diplomas. I've done college transcripts. In one case, I did a high school transcript. Anything we can get to kind of bolster this person. One of the, in the regulation, the judge is required to look at the whole person concept. So that's why, again, we have the conduct, but the more we can kind of bolster this whole person, this character information, so much the better. So we've got each guideline that states, each guideline that we're talking about, when the statement of reasons is issued, it talks about the specific conduct. And each one of them says, why we're going to pull it, and whether it's financial, drug abuse, alcohol, that type of thing. And I want to touch on that a little bit. In every one of these guidelines, there are mitigating circumstances. So I said there's the whole person concept, just generally good person, and then mitigating circumstances on what charges or what conduct they're alleging. Guideline E is personal conduct, and I think I've got some information in y'all's packet. And this is conduct involving questionable judgment, untrustworthiness, unreliability, or dishonesty. And there are certain mitigating circumstances that the government, or the judge, I should say, will look at in order to maybe say, maybe this person should get a clearance. For instance, one of the mitigating circumstances, the information was unsubstantiated or not pertinent to a determination of judgment, trustworthiness, reliability, etc. On the security clearance regulation, where this guideline E always comes up, it's the document itself. And here it is, all 19 pages. This is a security clearance application. I think the last 3 or 4 years they now do it online. They require it to be done online. It's now called, it's a SF-86, Standard Form 86, which has been in place for 20, 30 years. It's now also called an Electronic Personnel Security Questionnaire. Again, they require you to do it online. And I just kind of want to touch on some of the questions where I've seen folks, every one of these questions I read, I've seen folks get tripped up. They have a question on foreign influence, on former spouses. Let me talk about that for a moment. And they want to know if divorced, annulled, etc., where is the record located? And unfortunately with the volumes of divorces that are out there, there can be some, for lack of a better phrase, tawdry things put in a divorce pleading. So the government can access that entire record. If you simply have a cohabitant, they want not only the relationship to you and the cohabitant, they want that person's social security number, and that's kind of how this starts. As far as they have a question, I mentioned foreign influence. If you've lived in a foreign country, a question: do you have or have you ever had any foreign financial businesses, foreign bank accounts, or other foreign financial interests, etc.? Yes or no. Bear with me, they get better. Police record. There's a section that has about 8 questions. Have you ever been issued a summons, citation, or ticket to appear in court in a criminal proceeding? Have you ever been arrested by any police officer, sheriff, marshal, or any other type of law enforcement? Just arrested. Have you ever been charged with a felony offense? Illegal use of drugs, another 7 questions here. In the last 7 years, have you illegally used any controlled substance, for example, cocaine, crack cocaine, THC, marijuana, hashish, narcotics in this same question, or prescription drugs, including painkillers. Use of alcohol. Has your use of alcohol had a negative impact on your work performance, your professional or personal relationships, your finances, etc.? So pretty generic question. They're not asking about have you gone through rehab or anything like that. Financial questions. This can be a killer for folks. And what I'm talking about here is just the way these questions are answered, because under